Around the turn of the 21st century, cable companies used signal scrambling to prevent those who hadn't purchased programming from viewing the channel. Sometimes signal bleed occurred, briefly exposing non-purchasers to the program's images or sounds. A law aimed to prevent exposing kids to adult channels. One company claimed the law violated the First Amendment, leaving the government scrambling for a valid argument in United States versus Playboy Entertainment Group. Playboy made adult programming. Cable companies put Playboy's shows on channels that required a subscription or offered them for rent. Purchasers received a special box to unscramble the signal, permitting viewing. Signal bleed sometimes occurred with those who hadn't purchased the programming. Section 505 of the Telecommunications Act of 1996 required cable companies to shield kids from viewing channels that primarily provided sexually oriented programming without parental permission. Companies needed to completely scramble or block channels, including any signal bleed, or only transmit the channels between 10 at night and 6 in the morning. Most companies chose the timed option. As many as half of all customers who viewed adult programming did so outside of those hours. Playboy sued, asking the court to declare the section unconstitutional. At a bench trial, the government supplied a handful of complaints of signal bleed, but estimated that the potential for bleed was much higher. The court held that the government's interest in protecting children was compelling, but could be furthered with Section 504 of the Act, which required the complete blocking of a channel upon a customer's request. Though few requested blocking, the court reasoned that adequate notice of this option would sufficiently further the government's interest. The court found for Playboy. The U.S. appealed to the Supreme Court.